Good afternoon, everyone. Welcome to our second Clean Water Act webinar in our three-part series. Today we'll be talking about CAFO and wetland regulation under the Clean Water Act in Wisconsin. My name is Mike Engelson. I'm the Executive Director of Wisconsin Lakes. We're the statewide nonprofit conservation organization we work on lake conservation. Obviously, we represent lake organizations in the state as well. I want to thank all of our presenters of these webinars, which include the River Alliance of Wisconsin. So we have Bill Davis from the River Alliance, who is here. Midwest Environmental Advocates, our presenters will be from MEA, Wisconsin Lakes, as I've said, and the very great national network of river organizations, aptly called River Network, almost as apropos a name as Wisconsin Lakes, right? We're joined by April Engel, who'll be giving sort of a bit of background on the Clean Water Act for those of you who are in on this for the first time. If you attended the first webinar, it'll be pretty similar. Just a few of the typical ground rules for this Zoom meeting. I think I have it set so no one can unmute themselves, just so that we don't get lots of echoes or dogs barking or things like that in the background. So please stay on mute unless you're called upon. There basically will be two ways to ask questions. It's not too large of a group, so we may be able to unmute you when it comes time for questioning, but you can also type your question in the chat. When we open the floor for questions, if you want to, you can use the raise your hand function, which is probably down in the bar at the bottom of the screen. It might be under reactions. It might be under something else, because Zoom is never consistent. And even if you're on Windows, it can change from, it seems like, day to day. We'll cover as many questions as we can in the time it allows. You can always follow up with people. And this session is being recorded, so just be careful with what you say. It will be kept for posterity. And then really quickly, our next webinar will be on March 21st, where we'll be covering TMDLs and 9 key element plans. If you go, what are those? Then you should attend, because you'll learn. And then I also wanted to mention that we'll have a more advanced workshop on the Clean Water Act. That'll happen in person at the Wisconsin Lakes and Rivers Convention. It's at the Holiday Inn Convention Center in Stevens Point. You can get more information on that and the entire convention at wisconsinwaterweek.org. I guess that was the end of my slideshow. It was. I'm stopping share and will allow April to pull up her slides. And while she does, I will tell you that April Engel is River Network's advocacy director and has worked for over 25 years leading organizations, collaborating with partners to advance clean water policy, supporting individuals and organizations who are working together to protect and strengthen their communities and the places they love. In her current role, April provides training tools and resources and facilitates peer-to-peer exchange on a number of water-related topics, including using the Clean Water Act to protect and restore the health of our waterways. So please welcome April.
Thanks, Mike, and thanks everybody. It's great to see all of you here this afternoon, and I'm just really grateful to River Alliance of Wisconsin, Midwest Environmental Advocates, and the Wisconsin Lakes organizations for hosting this series. So as Mike said, I'm April Engel, and I'm the Advocacy Director at River Network. And to begin our webinar today, I am going to be sharing an overview of the Clean Water Act with you. So I want to just go over pretty quickly the key components of the Clean Water Act and how those components work together to protect and restore our waterways. So just to get us started, though, I wanted to just quickly, for those of you who may not be familiar with River Network, I wanted to just give you just a quick introduction. So we've been around for over 30 years, and during that time, we have worked really with our sole purpose being to connect and strengthen the network of water, justice, and river advocates who are working for water and clean water at the community, local, and state and regional levels all across this country. And we focus our work in 3 key areas. Those 3 areas are safe and affordable drinking water, healthy, resilient rivers and lakes, and climate resilient communities. And we support these goals through online, virtual, and in-person learning opportunities and trainings like this one that we're really happy to be a part of today, through development of resources and tools. I'm going to share a few of those with you today as well. We also convene peer-to-peer learning opportunities. We provide one-on-one technical assistance and facilitation. And then we do our own advocacy, especially at the federal level. And we also organize a national conference for river advocates called River Rally. And at the center of all of this is a focus on advancing equity, diversity, inclusion, and justice. So before we jump into talking about the Clean Water Act, I would love the opportunity just to get to know all of you a bit more today. So what I want to ask is if in the chat, all of you would take a moment and share your name, the organization that you're with, or you can share if the community or the river, lake, or watershed that brought you to the webinar today. Also would love to just hear some examples of water pollution impacts that you're seeing in your community or watershed or on your lake. And also, if you know what maybe some of these sources of pollution are, just to get an idea of what brings everybody to this webinar today. So I'm going to give everybody just a minute to put that in the chat, and then we'll take a look and see where everybody is attending from today and what some of the issues are that you're looking at in your community. I'll give everybody just a minute to answer those questions. Thanks, Janie and Bud. Great to have you all here today. Hi, Christine and Robert, Miriam, and Terrence. Hello to Cheryl and Michael. Great to have you all here. So it looks like some of the issues that are showing up in the chat are things like runoff from agricultural lands, as well as from residential, urban, suburban areas, nitrate and phosphorus pollution. Let's see, there's also legacy pollution from past land uses that folks are dealing with, some discharges from farmlands, historic contaminants again. Fluoride is definitely an issue that we hear about. Industrial contamination, a legacy contamination again. Impacts from both water and air issues from CAFOs is a concern. So thank you all so much for taking the time to share some of the issues that you're dealing with in your communities. And so glad that you're able to be here today, because I think this will be a really great opportunity for you all to connect with each other, and also to learn from the folks at Midwest Environmental Advocates about some of the recent updates and some of the laws and policies that could be really useful for you as you grapple with these issues in your community. So what I'm going to talk about, and what I want to do next, is just give you an overview of the Clean Water Act and how it can be used by you, and really is designed to be used by you, to address water pollution problems in your watershed, your river, lake, or community. So to begin, the information information that I'm going to be sharing with you all today in this brief overview comes from the Clean Water Act Owner's Manual. And this is one of River Network's longstanding resources. We first released this manual back in 1999, back in the 1900s. And a second edition of it was released in 2005. And we released the most recent edition in 2022 on the Clean Water Act's 50th anniversary. And Mike is going to put a link to the manual in the chat so you can reference it as we go through the presentation, or you're welcome to bookmark it. We really hope that you'll find the manual continues to be useful to you beyond today's webinar. Because it's really a how-to guide for how all of us can use the Clean Water Act to protect and improve the waters in our communities. And over the 20 years since the first edition was published, literally thousands of people have used this manual to apply the Clean Water Act to problems they're facing in their communities and watersheds. And over 12,000 water leaders across the U.S. have been trained on how to use the Clean Water Act to ensure that our waters are clean and safe, and to track and influence and change the way the Clean Water Act is being implemented at the federal, state, and at the local level. So the other thing I wanted to make sure that you were aware of is that we also recently launched a new online self-paced training that's based on the Clean Water Act Owner's Manual. And Mike's going to put a link to that training in the chat as well. Thank you for doing that, Mike. So this training is a 9-part series where you can learn the ins and outs of the Clean Water Act. You can understand each of the Act's programs and discover ways that you can use the tools of the Act and your local knowledge to advocate for your streams and rivers. So if you find during this webinar today that you're interested in learning more or going back and refreshing on some of the topics that we discussed, or you want to refer a friend or a colleague to some of the material that we covered today, this would be a great place for them to start as well. So diving in to our Clean Water Act overview, let's take a look first at the Clean Water Act vision and goals, which sets the stage for everything else that the Clean Water Act entails. So in the chat, Mike, again, thank you, is going to put a link to this graphic in case you want to refer back to it. But we'll be coming back to this graphic, or really like looking at this graphic throughout my entire overview. But that link will be there in case you want to refer back to it after today's webinar. So the goals of the Clean Water Act. So the primary vision of the Clean Water Act is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And it's important to remember that the Clean Water Act is not just about identifying and correcting pollution problems. It's also about understanding where we have good water quality and making sure that we maintain that water quality. The Clean Water Act also set interim goals and national policies to guide us on a path towards that lofty vision. So the first goal is to eliminate the discharge of pollutants into the navigable waters of the US by 1985. And the second goal was to achieve water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water by 1983. So you may have heard that the Clean Water Act says our water should be fishable and swimmable, and that comes from this second goal. Fishable is shorthand for the quality necessary to support the protection and propagation of fish and shellfish and wildlife, and swimmable is shorthand for the quality that we need to support safe recreation in and on the water. And while these deadlines being far in the past and knowing that we haven't achieved these goals yet, that can be discouraging. It also serves as a motivation to keep us working towards the vision and the goals set out in the Clean Water Act. And as I go through my slides, you'll see at the bottom that there are references to page numbers. Those are the page numbers in the Clean Water Act Owner's Manual. So if you're following along, you'll know sort of where we are in the manual. So moving on past the vision and goals, how did the Clean Water Act set us up to achieve that vision and achieve those goals? So the first thing that's important to understand is which waters are protected by the Clean Water Act. So the nation's waters, or waters of the United States, which are often referred to by their acronym, which is called WOTUS, are legally required to be restored and protected by the Clean Water Act. But how does the Act define a water of the US? So unfortunately, answering this question has been a moving target since the early 2000s. So back then, the US Supreme Court, well, since then, really, US Supreme Court rulings, and then subsequent agency rulemaking, and then repeals of those rules all came into play. And this is a piece of the Clean Water Act that we're going to focus on today. So more on that later. But for now, what's most important to note is this definition matters because it defines which waters are protected by the Clean Water Act. And unfortunately, a Supreme Court decision in May of last year dealt a really terrible blow to the definition of waters of the US. And that's now been codified into a revised rule by the Environmental Protection Agency and the US Army Corps of Engineers. And Rob is going to tell us all about this and what the impacts of this ruling are having here in Wisconsin. So moving on then to how the Clean Water Act is designed to achieve the vision and goals. So first, water quality standards are the foundation of the Clean Water Act's other programs. You'll remember one of the Clean Water Act's interim goals was to achieve water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water. So this led to the development of the Water Quality Standards Program. So water quality standards are just that. They're measurable standards that are set for each water body to ensure the visions and the goals of the act are met. So the responsibility for this program typically and primarily resides at the state and tribal level, but the Federal Environmental Protection Agency does have oversight. And water quality standards have three components. First, they identify how waters are used. So these are called designated uses. And then the water quality standards also establish criteria that protect those uses, the ways that the waters are used. And these are called water quality criteria. And then third, they require waters to be protected from degradation, and this is called the anti-degradation policy. The Clean Water Act also requires regular public hearings to get feedback on the adequacy of these water quality standards. And this process is called a triennial review because that process is supposed to take place every 3 years. Next, to meet the goal of eliminating discharges of pollution and to meet water quality standards, the Clean Water Act also regulates the discharge of pollutants into our waterways. And this is the other piece of the Clean Water Act that we're going to focus on today, and also what we focused on during the January webinar as well. So the Clean Water Act prohibits the dumping of pollution into water bodies unless that pollution is permitted. So to regulate the discharge of pollutants, the National Pollutant Discharge Elimination System, or NPDES permit program, was established. So the Clean Water Act allows states and tribes and territories to administer these permits within their jurisdiction. And most states do administer these permits, but EPA, again, does retain veto power if permits don't meet the requirements of the law. And these pollution permits are typically effective for 5 years and are supposed to be reviewed and adjusted as necessary to ensure that water quality standards are met and renewed at least every 5 years. However, many states are far behind in this process, and it's really common for permits to be administratively extended for several years beyond their expiration. And so that means that they are administratively extended without the review that would typically happen during the reissuance process. So next is to meet the goal of eliminating discharges of pollution and to meet water quality standards. The Clean Water Act also regulates dredging and filling of wetlands and waterways. So this program was set up to address pollution into the nation's waters that comes from activities that involve dredging in or filling of waterways by requiring permits for those activities. And those permits are known as Section 404 permits, which refers back to the section of the Clean Water Act that requires them. These permits are required of anyone who proposes an activity that would result in a point source discharge of dredged or fill material. So that would be things like dirt or mud or pollutants that are attached to them that would go into a water of the US. And Section 404 permits are commonly required for things like land development activities. So that would be things like construction of shopping centers or housing developments, building bridges or dams in waterways, and the development of things like new oil and gas pipelines. And the U.S. Army Corps of Engineers are responsible for issuing these permits, the 404 permits. And Rob's going to tell us more about this later in the webinar also. And then next, the other area is in order to ensure that federal activities won't violate the Clean Water Act, there's Section 401. And this gives states and some tribes, some tribes, as well as some interstate agencies, and at times even EPA, the authority to veto or place conditions on activities that require a federal license or permit that may result in the discharge of pollution into waterways within that jurisdiction. And through Section 401, states and some tribes have the authority to review these federal permits and licenses to ensure that they're in compliance with that state or tribe's water quality standards or any other state or tribal water quality requirements. And so some examples of federal permits and licenses that states and tribes would review under Section 401 would include things like dredge and fill 404 permits that are written by the U.S. Army Corps of Engineers. So those dredge and fill permits that we just were talking about, as well as licenses and permits that are issued by the Federal Energy Regulatory Commission. So that agency will is in charge of issuing permits for some dams as well as some oil and gas pipelines. So that's some examples there of when that Section 401 might be relevant. So now connecting back to the Clean Water Act vision, and in order to restore the integrity of the nation's waters, what we have to do in order to be able to do that is be able to assess and report on the quality of waters to know if they are meeting water quality standards. So we have to make sure that our waters are, that they are meeting designated uses, that designated uses are supported, that water quality criteria are being met, and that waters aren't being degraded. So every state is required to determine the status of all waters in their jurisdiction and compile all existing and readily available water quality data and information into a report that is supposed to come out every 2 years. That's called the integrated report. And again, that's due to EPA every 2 years. And the report must also include the state's determination of whether all designated uses are being supported, and a list that calls out which waters are not meeting those standards. And this list is called the Impaired Waters List, or the Section 303D list, after the section of the Clean Water Act that requires it. Next, the Act also authorizes funding to assist government, as well as non-governmental organizations and businesses to take action to meet the goals of the Act. So when impaired waters are identified, there are programs in place to restore those impaired waters. So 2 of these programs that provide funds address first polluted runoff from non-point sources of pollution. These are often called 319 funds after the part of the Clean Water Act that authorizes those funds. And then also improvements to our infrastructure that we rely on for clean water. So things like wastewater treatment plants, and funding for those improvements are through something called the Clean Water State Revolving Fund. Section 19 also requires states and tribes to prepare assessments of their non-point source pollution problems, develop management programs to address the problems that they identify in their assessments, and create a grant program that funds state and tribal programs for non-point source assessment and control. And these 319 funds for states are to be evenly split between funding non-point source management program activities. So that would be things like planning, assessment, management, and statewide projects, and then also watershed-based projects. The second step that's required to restore unhealthy waters is to identify a pollutant cap and develop a water quality restoration plan to address those impairments. And that's what we're going to focus on in the third webinar that's coming up next month on March 21st. And so at the federal level, the term total maximum daily load, or TMDL, which is the acronym, has come to represent both a pollutant cap and a restoration plan to get waters back to meeting water quality standards. So the pollutant cap, just sort of generally, a way to think about it is the maximum amount of a pollutant that a water body can receive and still meet water quality standards. The restoration plan describes how that cap is going to be achieved by identifying the sources of pollution that are causing the impairment and how much each pollutant source needs to be reduced in order to meet water quality standards. And surprisingly, implementation of a TMDL, of the restoration plan, isn't required by the Clean Water Act. However, it is now a common part of the process and often involves the total maximum daily load process, often involves changing pollution permits and using best management practices to control pollution to help us meet water quality standards. And finally, the Clean Water Act prioritizes public participation in its very first pages. Every single program that I just described provides opportunities for either public notice, public input, public review, though the way that happens differs across the programs. And the manual, the Clean Water Act Owner's Manual, can provide you a lot of information about ways that you can plug in. Most of the Clean Water Act programs have a mechanism to challenge the way they're implemented if they're being implemented in an unlawful way through either administrative appeal or through the court. The Clean Water Act Section 505 is devoted to a citizen suit provision, and that's similar to several other federal laws that have similar provisions. And this provision allows individuals and organizations who may be adversely affected by certain actions or inactions to file a lawsuit to enforce the Clean Water Act under situations like ongoing violations of a pollution discharge permit or a 401 water quality certification discharge that's happening, or discharges that are happening without a required permit, including NIPDs or 404 dredge and fill permits, or if EPA is not performing a mandatory duty. And all of the public input and review opportunities are just really vital parts of successful implementation of the Clean Water Act. And frankly, without it, the act just can't work. And that's why you are such an important part of successful implementation of the Clean Water Act. Oops, okay. So to wrap up my section of the webinar today in this Clean Water Act overview, I was gonna, in honor of President's Day, which is coming up on Monday, I'm gonna leave you with these words from a former US President, President Jimmy Carter. So President Carter wrote a foreword for the second edition of the Clean Water Act Owner's Manual. And in it, he speaks to the importance of clean water, provides historical context of how the Clean Water Act came to be. He shares how the act is designed to protect and restore our nation's waters, and highlights what still remains to be done, including a call to action for all of us to get involved in using the Clean Water Act's tools to protect our local waters. So I'll drop a link in the chat here since I'm wrapping up to this foreword that's on our website. You can read the whole thing. I think it's really inspiring, so I encourage you to go check it out. And if you want to share his words on President's Day or his call to action, River Network's going to have some social media posts on Mondays that will also highlight this. So if your organization wants to check that out on Monday and share any of those, we would be very happy for you to do that. So with that, I'm going to stop sharing my slides. Mike, are there any questions before I turn it over to Rob?
I don't see any that have come up at the moment. If somebody's got a quick one and can type quick while we're getting stuff shifted over, we can certainly entertain that. I'm also going to put in the chat the sign up link for the March webinar in case the stuff that April mentioned that is going to be covered in March is something that you would like to take a look at. And we'll get all that information to you again at the end. If you do have questions for April, she'll be here through the end, and at the very end, we'll have time to open up questions for any of the presenters. But I think we will move on to our next attorney, Staff Attorney Rob Lee from Midwest Environmental Advocates. He earned a political science degree from the University of Arkansas, law degree from Notre Dame. He was a Globes Environment and Society Fellow, served as president of the Environmental Law Society, and received the award for outstanding achievement in energy and environmental law. Spent summers working as a legal intern at the Michigan Department of Environmental Quality, and then came over here starting as a law clerk with Midwest Environmental Advocates. We're glad to have him here in Wisconsin with us, and he will be our next presenter. So take it away, Rob.
Thanks so much, Mike. And really appreciate that overview of the Clean Water Act, April, and look forward to taking some of those general principles, right? And for a second time here, since this is the second installment of our series, applying them in a Wisconsin-specific context. So as Mike mentioned, I am Rob Lee, and I do have the privilege of being a staff attorney at Midwest Environmental Advocates, located here in Madison, Wisconsin, where I've now been for 5 years and some change. And a good portion of my work does include working on wetlands. So I am going to cover regulation under Section 404 of the Clean Water Act, and in addition to that, how the state of Wisconsin regulates wetlands here. And after that, my colleague, MEA staff attorney Adam Voskuil, is going to bring us back to the WIPDES program, which we covered in our first installment in this series, right? But talk about it in a specific context, namely concentrated animal feeding operations, or CAFOs. So, but just real quick on MEA. MEA is a nonprofit law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. And MEA, throughout its now 25-year history, has specialized in Clean Water Act implementation in Wisconsin. And then the fact that our budget comes from private donations and grants rather than, for example, government funding, means that we really have the freedom to pursue environmental protection, right, and to enforce, the Clean Water Act, however necessary. So, feel free to find out more about MEA at our website, midwestadvocates.org. The link's there on your screen. And there you can sign up for our newsletter, podcast, or you can even submit a request for information or assistance through our intake hotline. So I encourage you to take advantage of that. Okay, so we have a lot of material to cover and not a lot of time. And I do want to ensure that there's time to ask questions at the end. But that said, feel free to put those in the chat as they occur to you, and perhaps we can get to some of them before then. But I just flagging, I am going to go through my slides quickly. But just reminding you that the recording of these webinars will be made available after that. So you'll be able to go back and review in case you miss anything. But in the interest of asking questions, to make just real quick though, I intend to just cover generally section 404 saga that was alluded to earlier in the case law over that, which really I think describes our federal jurisdiction. I'll compare that to state level jurisdiction. I'll describe the difference between individual and general wetland permits, show you the different general permitting standards, and then quickly discuss public input opportunities in the various processes. So I'm going to jump right in here. I think the biggest difference, right, that you'll notice between the WIPDES program under 402 and the 404 permitting program is that the permitting entity, the primary permitting entity, is not EPA, it's the U.S. Army Corps of Engineers. And Section 404A does require a permit from the U.S. Army Corps of Engineers to discharge dredged or filled material into navigable waters. That said, like the WIPDES program, the Corps is authorized, or states are authorized, to administer their own Section 404 programs instead of the Corps, right? This concept of cooperative federalism. But unlike the WIPDES program, where a lot and most states have, and the vast majority have taken advantage of that opportunity, right, to be the primary delegated permitting authority, that is not the case with Section 404. And in fact, only 3 states, Michigan, New Jersey, and Florida, have been delegated authority under this provision. And for a while, it was just Michigan and New Jersey. Florida has only very recently come to the game here and been delegated that authority. But this is all regulated under the Clean Water Act, right? And the regulation of really wetlands under Section 404 falls back on these regulatory terms of art and phrases in the Clean Water Act, like navigable waters, which means waters of the United States. That is not further defined in the Clean Water Act itself. So anyway, I think this is interesting because here, even though Wisconsin has not been delegated Section 404 authority, it still regulates wetlands. All right, so it's not part of the cooperative federalism things, but they certainly exercise concurrent jurisdiction. That requires us to venture slightly outside of the Clean Water Act, but for reasons I'll explain, in pursuit of another Clean Water Act authority named Section 401, it kind of all ties together and comes back to the Clean Water Act in any event there. So, but like I say, there's been a lot of debate over this phrase, waters of the United States. And so that should just say federal jurisdiction, not federal versus jurisdiction. So sorry about that typo. But to understand that saga on water of the United States, we need to understand the source of authority for the Clean Water Act, right? And I described this last time, but it's even more relevant here because it's the Interstate Commerce Clause. And we have to remember the Constitution as an instrument of limited government, and the federal government, right, only has the powers enumerated therein. Well, they use the Interstate Commerce Clause quite a bit, including to pass the Clean Water Act, right? So in the first instance, we're talking about impacts to waters that will in turn impact interstate commerce, right? So the first instance, of course, interstate waters, but what about other waters, right, that may impact those interstate waters? And how far does the Interstate Commerce Clause stretch? Is I think in the background here, and important to understand for the courts, like the Supreme Court's different approach, right, to interpreting this phrase, waters of the United States, right? So when I say interstate waters, or what I really mean there are just like traditional navigable waters, right? That are navigable. In fact, you can float stuff down them for economic purposes, including a watercraft. And we have this definition here from an 1871 case kind of defining what navigable in fact means, right? Can in their ordinary conditions be used as highways for commerce. Okay, well, we still have to consider other types of water features other than just those traditional navigable waters, right? And how they relate to this question of interstate commerce and what can count as a waters of the United States and not, right? So we won't get into the ins and outs of each one, but these are the different categories you see considered in the case law or in the rulemakings, right? Tributaries to those traditional navigable waters. Ephemeral streams, right? They're not really permanent. Maybe they just exist in response to rain events or however, right? But adjacent wetlands, this one right here is important, as you know, obviously for our question, but this is really what the court is keyed in on in terms of what WOTUS means and what wetlands it applies to. Right? Because what does adjacent mean? Does it mean that it actually has to touch? Does it just have to be nearby? Important questions. Interstate wetlands, isolated, non-navigable, intrastate waters and wetlands. I'll bring up this same list here in a moment after we go through the court's decision, and you'll see what's in and what's out. Okay, so, but there has been a series of court cases stretching all the way back to 1985, defining which wetlands count under WOTUS, right? Defining what the federal jurisdiction is. This is why I call this a saga, right? Because only until last year was this question, at least for now, more definitively decided, right? I mean, you can go back and review these cases. I won't describe each one. Right, but Riverside Bayview, a big Supreme Court case. This Swank case in 2001 was really important. Rapanos was important, but confusing for a lot of people because it wasn't, there was no majority of the court ruling in that case. We just had a plurality opinion authored by Scalia, which established this idea of a continuous surface connection test. If the adjacent wetland has a continuous surface connection to a WOTUS, then it itself is a WOTUS, right? But we had a concurrence there, Kennedy, which was actually what was adopted, given some funky rules on how to read Supreme Court decisions. Kennedy's concurrence, which was narrow, established this significant nexus test, right? Which, in my view, better appreciates or understands kind of the full hydrologic cycle rather than, oh, is there a connection on the surface of the earth that we can observe, right? Because that obviously doesn't quite get it. But some distinctions in between the two there, right? And people trying to figure out where to go from there, really until last year, right? When Sackett v. EPA came out and we had really a resolution, at least for the short term here. So the question there is, really, what is that proper test? Is it the significant nexus test, continuous surface connection, some variation of those, or some other test that the court needs to contrive that hasn't otherwise been? So that was really what it was getting at, but confronting some of those other issues, right, about the source of EPA's power here in the Congress's power with the Clean Water Act and tying that back to interstate commerce. So ultimately, the court effectively, with a little bit of tweaks to it, but effectively adopted Scalia's plurality opinion from Rapanos, this continuous surface connection test. Whereas EPA had basically been applying, now when I say that, I mean the Obama EPA, to a lesser extent the Trump administration, and then back right to the Biden administration. But all of them were really implementing some form of the significant nexus test or a lighter version of that, right? Here, this brought us back to Scalia's plurality, this continuous surface connection test, which means it removed acres and acres and acres, right? Really, we can't count them all. We don't know, from regulation, right, under the Clean Water Act, if they're no longer waters of the United States, then this prohibition to discharge without a permit from the Corps doesn't apply. So that can be very problematic, especially considering, right, that only 3 states were even interested in getting delegated authority. Now, maybe they're like Wisconsin, who has residual authority. But you may have heard, right, that I graduated from the University of Arkansas. Guess what Arkansas doesn't regulate, right? So we have is wetlands. So we have whole swaths of states, right, with no regulatory protection for wetlands that no longer qualify under this test. So here's the list again. Like I said, right, traditional navigable waters, they're always in. Tributaries in, they're in, but there's got to be that continuous surface connection, right? Ephemeral streams, if it's only in response to precipitation, it's out. It has to be relatively permanent. So technically a tributary could go dry part of the year as long as has relative permanence overall, and is not only there only in response to precipitation. Adjacent wetlands, what we're talking about, right, has to be a continuous surface connection. Interstate wetlands, they're out unless they qualify as an adjacent wetland. Isolated, non-navigable intrastate waters and wetlands, those have previously been excluded. But so these are just general categorizations though, right? And it's not as if we, again, can just survey all the wetlands in the country and know what's in and out, right? The specific, right, case-by-case determinations are made in the context of proposed projects that could impact those wetlands, right? And how that happens, as you'll see, is the last point here, is through jurisdictional determinations. The Corps will determine whether or not a water feature counts, and therefore whether it has jurisdiction over it. And so that's how you determine in a specific situation. But those jurisdictional determinations matter for another reason under state law. So Wisconsin is not like Arkansas and does have a robust regulatory framework for wetlands that is independent. There's interplay with the Clean Water Act, but it is independent from the Clean Water Act. It is not based on this lens of interstate commerce. That's not how we define wetlands in Wisconsin. We define them using a science-based approach, right? So while that impacts or limits the impact of Sackett in terms of there being any regulation, right, of activities impacting wetlands, I want to be clear though that it still removes that federal backstop, right, that we previously had for a lot of these regulations. And furthermore, there's some interesting interplay with the state regulations that increases the impact that Sackett may have here. But again, it's independent regulatory authority. It's in chapter 281-36, but you can see, right, they can't discharge. Instead of from the Army Corps, they need a permit from the Department of Natural Resources. Wetland, not tied to not only waters of the United States, but not even to our state definition of waters of the state, which you may recall is much broader than waters of the United States. Wetland is defined, again, based on science, and actually in chapter 23 of the Wisconsin statutes. It examines, based on that water feature, where the water is at. Is it near the surface? Is it above the surface, right? Can it support the type of vegetation typically found in wetlands? And what are the soil conditions, right? Like, are they wet? Are they indicative of what, again, we would expect to find in a wetland here, right? Is it actually a wetland? Not this contrived legal term of art, based on these 250-year-old constitutional principles. Is it a wetland? And if so, then you need that permit unless an exemption applies. But here's where it ties back to the Clean Water Act, because the state of Wisconsin also has the power to certify whether federal projects will meet state water quality standards under Section 401 of the Clean Water Act. And the issuance of a wetland permit in Wisconsin acts as a water quality certification by default. So even though this is an independent process, it still plays a role within the Clean Water Act. There are even more overlaps, right? I just talked about this interplay. Recently enacted exemptions to our state wetland regulations are expressly tied to whether or not there's federal jurisdiction over them. So there are two non-federal exemptions now in our wetland law, one that applies in urban areas under certain conditions, and I'm not going to go through right now, but that you can read later on, and also in more rural areas, right, as long as it's used for an agricultural purpose. Now, importantly, and thankfully, the DNR will not consider a wetland non-federal until they receive that jurisdictional determination, right? So that applicant, whoever's asserting it to be non-federal, they need to present the jurisdictional determination from the Corps, right, to show that it's a non-federal wetland. So at least there's some review there, but you can see with these exemptions that with Sackett, right, creating a whole new swath of non-federal wetlands, there is potential there to increase its impact here in Wisconsin. Another one, and I don't want to discount the importance of this for reasons you're about to see, but the discharge into artificial wetlands, another exemption. There's a list of conditions in the statute there as well, but that's actually been the most impactful so far. So DNR actually reviewed the impacts of these exemptions and released this data last year. You can search like DNR wetland dashboard and you should be able to pull up most of this stuff, right? So this is over a 3-year period before Sackett was released, right? From 2020 to 2022, you can see how many acres were filled based on the artificial wetland exemption alone, right? Now look at the non-federal exemption where when Sackett wasn't in place. But what's interesting is, you know, maybe that doesn't seem like a whole lot of acreage to you, but it is, especially if you repeat this every 3 years and every 3 years, right? Look at the difference between artificial wetland exemption acreage versus individual and general permits over that same time frame. The exemption alone, right? Now these are artificial wetlands. So we're already comparable on the non-federal exemptions with general and individual permits, and this is something we need to monitor going forward to see what if this ticks up at all. And certainly we anticipate it to some extent. To what that extent is, we certainly don't know. But there is an expectation that those exemptions will increase. Okay, chugging along here, there's the same dynamic that there was with the WIPDES program with individual and general permits. Recall that general permits are permits that cover categories of projects. So it's not really thinking about a specific project, but types of projects that have kind of consistent minimal impacts that can be regulated using the same permit conditions, right? These are permits that people apply for coverage underneath, but it's different than an individual permit where that is contemplating a specific project that is more complex, may have more significant individual impacts, don't qualify under a general permit, right? So you know, that's the difference there. And I'll talk about public input opportunities with the both in a sec, right? But it's different in the sense that we have both federal and state general and individual permits because there's concurrent authority, but not that delegated cooperative federalism. So we have permits from the U.S. Army Corps, individual permits there, and their general permits, which are typically nationwide, regional, sometimes state specific, right? But and you can find a list of those types of general permits on their website right there. But nationwide, regional permit, if you hear that, they're talking about general permits. The state has a statutory list of general permits that it must issue under its program, and it has a couple others in addition to that, but you can see that list there at the available link. Okay, just real quick into permitting standards, and I want to do a time check just to make sure here. I'll cut to the chase at the end here. What's interesting about these two standards is how, if you really get into them, similar they are. And that's what I get to at the end. They talk about things in slightly different terms, but it's, hey, you need to analyze alternatives. If there's a reasonable one that would avoid impacts, right, to those wetlands or would minimize those, again, and it's practicable or reasonable, you really should explore that, right? And this idea of the nation's water would be significantly degraded, or there would be an impact to wetland functional values, right? These are very similar standards, right? On the whole. So you need to assess alternatives to avoid or minimize impacts, take actual steps to minimize those impacts, and for the impacts that remain, importantly, provide compensatory mitigation to offset those impacts, right? The ones that you can't avoid. These features exist at both levels. Now, the programs overall are implemented by different entities and interpreted differently, but they're so similar, in fact, that DNR and the Corps actually have a joint application process. And if you're applying for like a waterway permit in addition to a wetland permit, which you also may need from the Corps, you would submit what's known as a RAP, or a water resource application for project permits, which then gets forwarded to the Corps. Now the entities follow up with you independently, but there is that joint application process. So it's just very interesting. So what this does, though, is requires entities to consider their impacts to wetlands. And to do that, they have to quantify what those impacts are going to be. And then they have to look at alternatives and quantify those impacts. And if practicable, go with the marginally better version of that, right? And if they can't, then they have to enter into mitigation, right? Well, mitigation is super important here, and it's crucial that we accurately characterize the impacts to wetlands so we know what needs to be mitigated. I won't get into the different types of mitigation, but it can get complicated, but there are options there. Okay, here are just some links to where you can find permitting materials for wetland permits. At DNR, you do have to go through their e-permitting website, and it is a little clunky even to get their public notices. Sometimes it's just hard and it's a little opaque to navigate it exactly, but you can filter it by location and things like that. So I'll just encourage you to maybe go there and poke around. St. Paul District Public Notice, it's basically like a news feed that's in chronological order. So you can just scroll down it. There aren't, I don't think, as many options to search it, though. I said I mentioned public participation. Reminder, general permits. Public participation occurs when the general permit is issued, not when project applicants apply for coverage under those permits. So it's important. Individual federal permits, there is a 50 to 30-day public comment period required. It may be extended. Public hearing is optional, held if necessary. At the state level, there's also a 30-day public comment period, but a public informational hearing is optional, although available by request by 5 or more persons. And then to the extent we're talking about a Clean Water Act violation, I don't get into it, but I'll just remind you of those citizen suit provisions that April talked about previously. I will conclude there and turn it over to my friend and colleague, Adam Voskuil, to hop into what I know everybody's dying to hear, which is his talk on CAFOs. So Adam, without further ado, unless Mike, you want to do his intro, I apologize.
Yeah, I'll just do a quick intro for him. And if you have questions for Rob, feel free to type them in the chat. We will get to those at the end, I think. But as Rob said, we will turn things over to Adam. And so while he gets his slides set up, I will tell you that Adam Voskuil, another staff attorney from Midwest Environmental Advocates, graduated from UW-Madison, degrees in conservation biology and sociology, certificates in environmental studies and the integrated studies of science, engineering, and society. Got his law degree at University of Minnesota in the Twin Cities with an environmental and energy law concentration. Law clerked at Midwest Environmental Advocates, law clerk for some judges in Dane County Circuit Court. So has a really great background and is going to talk to us about CAFO permitting in Wisconsin. Welcome, Adam.
There we go. Had to make sure I wasn't muted. Sound check, can you hear me? Perfect. All right. Well, good afternoon, everyone. Thanks for joining. And as you can tell, you get attorneys talking, and those last 3 slides almost always are a rush through as we realize we're maybe a little over time because we're a little wordy. So I will try my best to keep this succinct. I just want to let everyone know my goals for this, for my presentation, are to really make sure that we're starting at the base level, and I want to make sure that by the end of this, folks may be conversational in these terms. They know where you all will know where to look for resources, and you may have a starting point of knowing how to find the applicable law as it relates to CAFOs, and then ideally, the best part is that folks become effective CAFO commenters. It's one of the most impactful ways to engage on this topic is commenting and working on CAFO permits that are noticed and issued by the Department of Natural Resources. So with that in mind, I will jump straight into it, and you'll be able to tell I am to some extent a visual learner, so I have a lot more pictures. So like I said, starting at base level, what is a concentrated animal feeding operation, or a CAFO? CAFOs are, animal feeding operations range in sizes. Large CAFOs have a specific designated regulatory term. They're defined both in the Federal Clean Water Act and in the state and Wisconsin statutes. Well, I think it's NR 243. So administrative codes. But large CAFOs are defined as 1,000 or more animal units. An animal unit is, again, a specific regulatory term. It relates generally to the amount of waste that the specific animal produces. So you can see on the right side of my screen, I've got a collection of basically the equivalent of 1,000 animal units. So the equivalent size of an animal feeding operation, where it then becomes a point source and a regulated entity under the state's delegated WIPD's permitting program. In Wisconsin, we most typically see dairy CAFOs. So the 715 animal unit equivalent is the one that is most often triggered, but it's not only that. And sometimes you see a mix of CAFOs of animal types. So you can have some milking cows with calves, obviously a collection of various pigs. Rarely do you see like half of it is chicken and the other half is dairy. But I guess I'd never say never. But the point to know is that it's important to understand where these metrics or where these lines hit, because that's the point that DNR starts requiring permit applications, permit materials, and that's the point that folks on the ground can start engaging in the regulation of these entities. I think I saw someone in the chat earlier on note that they work on small and medium sized operations. This presentation is not necessarily going to focus on those. There is an instance in administrative code where operations that have fewer than 1,000 animal units may be regulated or may be required to seek a permit. But my talk is going to focus exclusively on those large CAFOs. So now that we know the size, I think the next question is, why do we care about them? Why are they regulated by the Clean Water Act? And that's because their waste is generally or typically stored in large, like open air lagoons. You can see in the picture on the top left, those beautiful pools of water that you can see kind of the sky shimmering off of are pits where manure, excrement, and processed wastewater are stored. So not maybe as beautiful as the visual entails. And moving onward, we care about them because they store that manure and because they exist in pretty high numbers around the state. So in Wisconsin, I actually end up having to change this number almost every time I do one of these presentations or do a CAFO type of presentation. The numbers usually go up by a handful or two handfuls. So last fall, the number that I had was around 327 large concentrated animal feeding operations in the state. As far as I know now, we're closer to 335. And one of the interesting things to note about large CAFOs is that they're not, equidistant apart. They tend to concentrate in certain areas. And unfortunately, when you look at that mass that's in the northeast portion of the state, up in Door, Kewaunee County, Brown County, Outagamie, Fond du Lac, Winnebago, Calumet, you see that concentration. That's also a place that's been known to be exceptionally sensitive. It's known for having karst topography or Silurian dolomite, this idea that there's shallow depth to bedrock, so the water table is relatively close to the surface, and also it's fractured carbonate bedrock. So the bedrock in the ground is known for having sinkholes or fractures that create direct conduits to groundwater. And for reasons that I'll talk about in just a bit, in Wisconsin, we care about those direct conduits to groundwater as it relates to permitting in the state. So like I said, CAFO numbers are continuing to rise. They have for over the last 30 years. It's been, as you can see from that chart, relatively consistent or linear, I guess. In addition to the northeast portion of the state, karst topography, though at a deeper depth to bedrock, exists along the southern and western portions of the state. And even the central portion of the state, the central sands region, is known for being particularly porous, having sandy soils that again lead to relatively easy discharges to groundwater, again, raising concerns. So it's not like there's a really safe, great place to site 300 CAFOs around Wisconsin. They're concerning anywhere, but they may be concerning for different reasons. So let's talk about, I pulled this beautiful graphic. Let's talk about how CAFOs discharge and why we care about it. And so I'm going to focus largely on the bottom portion of the graph rather than the air emissions and the deposition. So like I said, CAFOs store, if you start at the CAFO barn on the left, CAFOs store manure and process wastewater in lagoons. Those lagoons are known to leak. There are national standards, NRCS standards, that allow for a certain amount of seepage or transmission from lagoons, whether they're concrete lined or clay lined or earthen lined. There's an allowable seepage or a discharge to groundwater, to the water table. That's why you see that arrow going down. In addition, it happens every once in a while, lagoons overtop, whether that's because they don't have CAFO doesn't have enough storage, they haven't been able to spread in a while, or there's significant rainfall events. You see overtopping of those lagoons. Similarly, that manure can flow into and either settle and make its way down to groundwater or move to surface waters. We've seen fish kills in recent years from manure lagoons overtopping. Post storage in the lagoons, it eventually has to go somewhere. And so CAFOs will pump the lagoons into trucks and drive those heavy manure laden trucks into to nearby agricultural fields to spread the manure and the processed wastewater on fields, to some extent as fertilizer, but also because the animals are continuing to generate waste and they need to get rid of what they have in some way, shape, or form. We saw a study come out in 2021 that it was an analysis of manure spreading across Wisconsin, and they noted that typically the manure is spread within, I believe it's 1 mile of where it's generated, so the farm that it's produced at. I think it's pretty obvious that CAFOs can't be spreading all of that manure, those hundreds of thousands of gallons, those millions of gallons of liquid waste that are generated a year. But there is an economic constraint. So as a result, CAFOs do typically tend to spread and maximize the amount of spreading on fields closer to their operations rather than further away. And spreading on the fields can lead to, as the picture shows, leaching to the water table, but also runoff through rainfall events that may lead to flushing the fields. And that's where you see contaminants like phosphorus make their way to surface waters, and those have ties to things like algal blooms, fish kills, things of that nature. And so you continue to see kind of the runoff down all the way into the surface water where someone is joyfully swimming. But the point of this picture is basically just to show how connected all of these practices are, and how the discharges are not just exclusively to surface water from a single action, but they're occurring constantly, from the discharges from the lagoons to potential spills to leaching from fields to running off of fields, all maybe making their way to surface waters, but maybe also just making their way to the groundwater table, where a private drinking water well, something that a high percentage of rural Wisconsinites rely on for their drinking water, may suck up that water, and they may be dealing with nitrate exceedances or pathogen contamination of their drinking water wells. And I wrote, so I'll just note here, the federal versus state distinction of discharges. I think I was planning to talk about this later, but I put it here, so I'll address it here, I guess. So the federal Clean Water Act regulates CAFOs in a different way. And you've heard today already from both April and Rob about waters of the United States. And the difference is that the federal Clean Water Act does not regulate groundwater. Conversely, Wisconsin's delegated program requires that WIPD's permits specifically address and ensure compliance with Wisconsin's groundwater laws. And so CAFOs in Wisconsin are required to not only comply with or have permits that address surface water discharges and surface water contamination, but also address groundwater and potential groundwater contamination and exceedances at neighboring wells or points of standards application. So I just wanted to use this to highlight that the groundwater table discharges that you see from the lagoon and the leaching off of fields are things that are addressed to some extent, or are supposed to be addressed in Wisconsin's WIPD's permitting program for CAFOs, but are to a lesser extent are addressed by their federal counterpart, the EPA and other states. That being said, there's been some question back and forth recently about a recent Supreme Court decision, not Sackett, but Maui, and its ability to tie in some groundwater discharges. But for general purposes, I think it's an easier kind of delineation to note. Wisconsin is definitely intended to address groundwater discharges made by CAFOs in the permitting program. So really just want to briefly touch on this again with the hope of making people conversational in some of these terms and just understanding the threats that CAFOs pose. I'm going to mainly focus on the top two with the rest of this discussion, and that's drinking water contamination through groundwater discharges. And that's, again, nitrates that can cause blue baby syndrome. They've been tied to thyroid issues, colon cancer, a number of kind of adverse health effects. It historically had been described as adverse health effects in pregnant women and young children, and then it was risk populations, and now it's I think studies have continued to come out to show that it may be broader than that, and everyone may be affected by a consistent nitrate exceedances through groundwater contamination or drinking water contamination. And then surface water degradation, I already noted. Fish kills, algal blooms, toxic algal blooms, really a loss and a reduction of quality in kind of waters across the state, surface waters. And then you just recognizing there may be air quality declines from things like hydrogen sulfide and ammonia, diminished property values that have historically been tied to nitrate exceedances, and then that increased truck traffic, which is almost like a tertiary effect of having CAFOs sited in a region and this almost destruction of the roads, but something that the folks that go through our intake line, as Rob referenced earlier, tend to focus on quite a bit. So let's get to the meat of why everyone is here. Clean Water Act permitting, or CAFO WIPD's permitting in Wisconsin. As I noted, Chapter 283 of the Wisconsin statutes does define point source to include CAFOs, and we actually have a case from 2001, Maple Leaf Farms v. DNR, might be 2002, that notes that also ties in actions that aren't just the production site. So historically, there was a question as to whether or not DNR could regulate or should be regulating where the cows are kept, where the or not cows, where the animals are kept in general, and the manure lagoons. And Maple Leaf Farms also noted, no, DNR through their permitting program also has the obligation or the duty to, or at least the authority to address the spreading fields that the operations are using to get rid of their waste. And that, to some extent, and as I noted earlier, is all of this authority is based on the expansive definition of waters of the state, which includes groundwater among a number of other long list of types of waters. And it's relying on that authority that DNR uses, that broad authority to regulate CAFOs. And now seems as good a time as any to mention a relatively recent win that we had in Wisconsin that affirmed this authority further. In May of last year, we had an industry group file a lawsuit asking a judge to find that the Department of Natural Resources could not require that CAFOs apply for and hold a permit to operate. Basically saying that based on federal case law from 2005 and 2007, or maybe 2005 and 2011, as well as the federal definition of waters of the United States, that our DNR couldn't behave in a way different than that, and essentially say that we could only do as much as the EPA is doing. The response to that was obviously that the definition of waters of the state is broader than the federal counterpart, and our state's groundwater law, chapter 160, specifically says that it's intended to be incorporated into the WIPD's permitting program, and that's also kind of mirrored in Wisconsin statutes chapter 283. And so based on that authority, a couple weeks ago, after hundreds of pages of briefing and months of working on this and an hour of oral argument, a judge in Calumet County agreed with the Department of Natural Resources, represented by the DOJ, and the interveners, defendant interveners, Wisconsin Farmers Union, which MEA represented, and Clean Wisconsin, and affirmed DNR's authority to require CAFOs to seek permits. So it's because of that we can still recognize and understand that all large CAFOs in Wisconsin must apply for and hold a permit to operate. So good news. Moving forward, I wanted to talk through what the permit process looks like for CAFOs, again, with the goal of knowing or people understanding where they can get involved in this. So about 12 months before a proposed CAFO is planning to operate, and I just did a time check and I'm gonna have to rush through a number of these. They start submitting a preliminary application to the DNR, but around 6 months before, the DNR will upload a lot of those things through the final application to what I call the e-permitting site. Sometimes people at ENR will call it SharePoint, which is just a general cloud storage. Rob had it linked as the water permits search link on his slideshow. From that point, interested folks will just have to kind of be aware that documents may exist online, and it might be valuable to regularly search for specific names of potential CAFOs and start pulling and aggregating those documents. Those will include things like, I think it's on the next page, an environmental analysis questionnaire, an NMP, a nutrient management plan, how they plan to use the manure and the fertilizer that they'll be spreading through the 5-year permit term, runoff controls, things like groundwatering, if DNR will be requiring it at the production site or at fields, manure and waste storage, engineering specs. It's all very technical, but that's where it all exists. 30 days or once kind of the permit has been reviewed by DNR, the application, they will draft a draft permit, and then they'll notice it with their basically an intent to issue it and put it up for public comment for 30 days. Interested individuals, again, this would be the part that people can be part of the process by submitting written comments to the Department of Natural Resources based on the terms of the permit itself. And at the end of this slideshow, I have links to where you can see all the permits on public notice, which include CAFO permits. At this point, individuals or community members can also request a hearing. If 5 or more interested folks request a public informational hearing from DNR, DNR is obligated to hold that hearing. And so you can both extend the length of a comment period, but also give an opportunity for DNR to talk through their reasoning and force them to listen to folks who may not want to or may not have an interest in submitting written comments, but feel strongly about the issue and would be willing to talk to the department in a Zoom call, say. After a month or two, or sometimes longer, depending on how many comments are received, DNR will typically issue a notice of final determination, ultimately issuing that permit. And then from that point, there is essentially a 60-day period to challenge that permit in a contested case hearing. I don't get into contested case hearings. By the time you get to that, I really think you need to be represented by an attorney rather than kind of going at it through a layperson's lens. So like I said, this is what's typically in the permit application. And moving on, just giving a brief view of what a WIPDES permit looks like. This is just the cover page of a CAFO WIPDES permit. It looks largely like most other WIPDES permits issued in the state to other industries. But important to note, again, that there's an indication of where these CAFOs discharge, and it's to a large swath of areas. It's to tributaries of the Anape River watershed, the Lake Michigan drainage basin, and just generally groundwaters in the state, recognizing that these have a very large footprint and they're discharging in different areas and in different ways through seepage and runoff. Just briefly looking at this second page, I highlighted a few things that may be worth looking at. If you're looking at a permit and just want to know a starting point, there are things like groundwater monitoring requirements that I've outlined in blue, and then things that are just interesting things to note, like an animal unit maximum, if it exists in a permit. Some CAFOs are limited in the size that they can grow to. Nutrient management requirements, which will indicate needing to meet certain standards like NRCS 590, a requirement for submitting annual reports so you know when DNR should be accepting them and when you can review them publicly. And then things like engineering evaluations for those lagoons in case there are leaks or cracks and we see kind of more catastrophic leakage than the typically allowed. I think I have basically just 2 or 3 more slides, but the whole takeaway point of this is that there are a lot of ways to impact permitting, and the starting point is reviewing the materials that DNR has and tracking what permits come out. Typically folks hear about whether or not a CAFO is coming into their community by a CAFO talking to various landowners or buying up land, or just sometimes someone is just kind of perusing submitted documents to the Department of Natural Resources and comes across the fact that a CAFO is looking to site in a specific area. From that point, it's where the rubber hits the road and organization really needs to happen relatively quickly. And that's why I'd recommend, again, at the end of this, using the resources that we have, how to track and aggregate the data, and then looking at MEA's CAFO guide as well, because we've also documented a lot of these processes in written form. Submitting comments on CAFO permits, again, you have to tie, because they're water permits, you have to tie these to water quality. A lot of times the folks that are commenting just are saying, this is going to hurt the property value of my house, or DNR can't do this. Comments are most effective and most successful when they're tied to surface or groundwater contamination and the actions and terms within the permit itself. Highlighting any inadequacies of the actual permit submitted documentation, like failures in an environmental analysis, or potential inadequacies or lack of spreading fields, things like that. This is a list of the typical ways in which we see CAFOs violate their permits, including spills or unlawful spreading during rainy seasons or when it's frozen. I'm not sure what fills was meant to be. I guess I drafted this page a little quickly. And then over application on fields is one that people are concerned about pretty regularly. Again, because there's such an economic constraint on spreading further out, we see people that are really concerned with spreading too much on fields nearest to the CAFOs and its effect on particularly those neighbors, groundwater, and potential contamination there. And yeah, this is just a last point of noting, if you're interested, there are a whole bunch of ways to get involved. It's not just at the DNR, but also local advocacy, engaging in sampling and testing, community work and engagement, and pushing your local governments to act as well. That's always an option. So here's some resources. I believe these slides were shared. And if so, these are great ways to get started and to find resources and information. And like I said, we're a bit wordy when you get attorneys talking, and I apologize for just kind of blitzing through this whole thing. All right, happy to take some questions.
Yeah, totally understood. that it's not just attorneys, it's everybody, right? And we started a little bit late, so we're actually pretty much right on time. I think we're doing just fine. So we have a couple of questions that are in the chat. Then we're a small enough group that I think we'll just open it up. People will be able to unmute themselves and ask questions. But fortunately, it's a balanced set of questions, one for Rob, one for Adam. So and don't forget, if you have questions for April too, you can ask her. But we'll start with Rob. Deborah asks, if an individual wetland permit is issued before public comment is allowed, can the permit be changed or reversed?
Yeah, thanks, Deborah. I mean, generally speaking, when we're talking about an individual wetland permit, whether being issued by DNR or the Corps, a written public comment period is required. So that can certainly be a procedural violation if that requirement is not observed. Now, how that impacts, like, you know, the review of that permitting decision during like a legal challenge it depends. I'll give you the lawyer answer, right? It's highly dependent on the exact like circumstances and how that manifested, right? But could be grounds for reversal to go back and hold a public comment period, right? Cure that procedural deficiency. So I can't like recall a standalone challenge like solely based on the failure to hold a public comment period. Because there's always some sort of substantive claim tied to the challenge, right? To those procedural claims, like, hey, if you would have held that public comment period, you would have considered this information we would have submitted that would have resulted in this change to the permit condition, right? So, you know, under that scenario, if a new public comment period were ordered, permit terms could be changed based on that new information submitted during the public comment period. But how that shakes out exactly depends exactly on the circumstances.
All right. Next question is for Adam. Do CAFOs require an environmental impact statement? And if not, would that help or hinder, in your opinion?
Yeah, so up until 2014, CAFOs were either preparing an environmental impact statement or an environmental analysis. In 2014, there was a rulemaking to essentially change the code related to environmental review that added issuances of CAFO WIPD's permits to what's called the integrated analysis activity. And so at that point, now what happens is CAFOs fill out, the CAFO owner operator, the applicant fills out an environmental analysis questionnaire, answering some questions about whether or not there will be any adverse impacts to the environment of the area or to important cultural resources. I want to say I've seen it range between like 7 and 12 pages. Sometimes it may go longer, but that's typically the average. But I've pushed, and the folks that I've worked with have pushed in the past to require a more robust environmental analysis or an EIS of some sort. The most recent one that I know of was, so DNR retains the discretion to require an EIS, but it's rarely used. You have to kind of show that a collection of factors are met in NR 150.30 sub 2. But the last time it was shown, it was for a proposed hog CAFO up in Bayfield County. I believe the name of it was Badgerwood in 2015. And it was so onerous to prepare that environmental impact statement and just aggregate the data. And probably it became clear as they were going that this was not a great place to site within 2 miles of Lake Superior, not a great place to site a concentrated animal feeding operation. Then they didn't go through with the process. They just stopped submitting things to the department. So I think, yes, it would be beneficial, even if it wasn't an EIS, though I'll always fight for an EIS, if there was a more robust environmental review in general that wasn't just created by and generated by. I mean, like when I read the current EAQs for some of the CAFOs, their analysis of like what the effects of their operation may be, sometimes are limited to just like, we're going to bring an economic boon to the city. And like, that's not an environmental analysis of the impacts. And so, yes, I think that there's value in really interrogating what's submitted to the department. Certainly something that I do every time I'm looking at a proposed CAFO permit or proposed application, and asking for more, because DNR does retain that discretion.
You should be able to unmute yourself. So if you have other questions, please feel free to go ahead and do so. I don't think there's enough people that will talk over each other. So go ahead.
Well, while you're figuring out if you've got other questions, just a couple of things I wanted to say. And again, this came up last time. Part of the reason why we're doing this series is just so you guys know that our organizations are also here to be a resource. We know that we blitzed you with a lot of information. We have all of our contact information on here. So if you've got questions on down the road, please feel free to get a hold of us, because we know how complex this all is. And the other thing, and Adam, you can tell me I'm wrong, but particularly when it comes to CAFOs, one of the ways that you folks are really, really, really important is they are supposed to say in their application where they're going to spread their manure. And there have been instances, frankly, where they have lied, where they have said that they had contracts with certain landowners, and then the neighbors went and talked to those folks, and those contracts didn't exist, or they weren't nearly what they had reflected. And it's that kind of ground truthing, particularly for CAFOs, that can be really important, because what they're going to do with that waste can be a real Achilles heel to that whole process. So just to say, I mean, this is where, the fact that you guys know your area, and that's a particular, relatively easy thing to look at. It's not as technical as the engineering standards for their lagoons and things like that. But it can be very, very important in whether the thing goes through and what it looks like.
That's right. That's actually happened pretty recently, that there have been questions on land disputes, I guess. Both, we had a couple different examples. One where a CAFO basically just said, you don't need to worry about it, Wisconsin DNR. We're going to spread over state lines. But they didn't provide any information. And it, the DNR was like, absolutely not. We need to know more information. And they denied the application. And we're still like a year from that point. And then other times where, neighbors were the ones that were like, we never agreed to this. Or sometimes there's a change in hands of the land itself, and the CAFO owner operator just kind of presumed that they could spread without actually doing the legwork. And so, it's really important for the folks on the ground, because you guys are the ones that would know. It's hard for us to kind of ground truth that. Though I still argue that DNR has the authority to ground truth if they ever wanted to use that authority in NR 243.
We've got one hand raised. I know we're kind of at or a little bit past our time, so we'll take the one question and then I'll end the recording, but we can hang on. Florence, you've got,
Just jump in before you go to Florence. Just real quick, there were two additional questions in the chat. I think that got overtaken by comments. It was by Michael. Adam is going to follow up with one via email. But I would like to answer the other one because it's important. Okay, sure. Really, for this discussion, I want to make sure everybody understands the definition of continuous surface connection. So the court in Sackett defined it how I listed it on my slide. So when you go back and refer to them, right, you'll see these two bullet points in there, how the court held in Sackett. But in defining those adjacent wetlands and continuous surface connection, it really is just this sort of very general definition. If it's adjacent to a water body that constitutes a WOTUS, right? That itself is connected to a traditional interstate navigable water, or that continuous surface connection, here it is, making it difficult to determine where the water ends and the wetland begins. That's the guidance from the Supreme Court. So while I say they settled it in so far as they decided or settled on a standard, it really is anybody's guess. Yes, EPA implemented this standard in its 2023 conforming rule, but it's really just kind of parroting this and striking the things that were inconsistent. It doesn't do a good job fleshing these out, right? Furthermore, even that rule is subject to legal challenge. So the answer is it's anybody's guess, but the best guess is to simply fall back on the Sackett itself, perhaps can read Rapanos and go through that 2023 conforming rule. But yes, the test has been settled, but how it actually applies remains to be seen, and it's something we all need to pay attention to. So I'm sorry, Florence, please go ahead.
That's okay. The DNR provides public commentary. And in a recent hearing regarding a CAFO in Crawford County in Wisconsin, 1,200 people testified, and it was ignored. There is a Wisconsin Natural Resources Board that supposedly is a panel that provides public input into the DNR. I'd like to know, what is it that we, as not being lawyers, but just the public, how do we regain some power from these basically sham hearings where it's simply not effective? We simply don't have the power to overturn or to get the DNR to do what they're supposed to do. And so I plan to give some testimony on February 28th to this Natural Resources Board. What do I say? Because if they're going to have hearings and say we want to hear from the public, how do we ensure that they listen and that something comes of it?
That's a very good question. To start, I'll note I have worked with the folks in Crawford County on CAFOs, or the CAFOs, or CAFO, depending on whether you think of it as singular or plural,
Right.
as it's singularly owned. But I can at least say from that experience, one, how frustrating it was, but two, how concerned I think DNR was by the sheer pushback that was felt from the community. I know that there were campaigns to bring in state legislators into the fold, letters sent to the secretary. So I just want to at least start by noting, like, while the outcome was not favorable, it did have an impact on DNR and their decision making. I know that particularly for the EAQ, that's one of the few EAQs where I saw they went back multiple times to try to backfill the record to make sure that there was some amount of environmental review there. I can disagree with them on its robustness overall, but there was kind of non-visible work that occurred as a response to the folks there. I think the Natural Resources Board sets policy for the department, and while there may be some kind of tangential impact in letting them know dissatisfaction with particular actions, they focus a lot more of their work on regulations and rules instead. And so it may still be worth expressing dissatisfaction to let them know, like, they're not doing enough. But I think consistently reaching out to the, because the CAFO is permitted now, doing some of that work related to the monitoring and sampling, and then even kind of really digging into the regional specialist, not digging into them, but keeping them apprised and making sure that they're being as on top of the CAFOs there as possible, are probably the most effective ways to maybe not enact change, but enact more adequate and reasonable oversight. In terms of change, I think if you wanted different changes in how the DNR goes about responding to public comments, that's changes to things that are in NR2. It ultimately is probably requiring change through actual rulemaking. And I'd be happy to chat with you more about that offline, but it is that's a longer, kind of bigger question to kind of create systematic change at DNR. And unfortunately, I don't have all the answers right now. We've been thinking about systematic change at DNR for years.
Well,
That's a citizens advisory board that that was appointed for the Minnesota Pollution Control Agency. And it was very effective, and it was able to overturn the Pollution Control Agency's decision-making. However, Governor Dayton at that time was politically pressured to dismantle it. And so he did. But that's what we need, is a citizens advisory board that has some clout, that has some teeth. Otherwise, it just goes on. And we're at the mercy of all of the siloed information.
we need a public intervener who is advised by a citizen advisory board, which we
Correct.
had in Wisconsin until 1995, right? And is one of the gaps MEA tried to fill, but that was a good fix anyway.
What a
Adam,
last
Intervener till when? 1995?
thereabouts.
Yes.
yeah, something like
Okay.
that.
Okay.
We'll end on that dip back into the last century, the halcyon days of the 1990s. So I think some of us probably would be able to hang on for a little longer, but I just wanted to end the recording and thank everybody, all of our presenters today. The link to the March 21st webinar registration page is in the chat, as is the link to the Wisconsin Lakes YouTube channel, which will be the home to the videos. The first webinar is up there now, so you can check that out, and to all links to all of our organization's websites. So we hope to see you March 21st, and then maybe at the Lakes and Rivers Convention in Stevens Point as well. So thanks to everyone, and have a happy Valentine's Day.